So basically, we have to understand that as engineers, as contractors in the future, as builders, as service providers, as long as you are providing some form of services or products or your actions, there will be some, if your actions actually causes some harm to a party, usually injuries, and all the damages comes with all the injuries, you need to pay for it, you see. And of course, there are these cases here it will be expanded over different times, you see. So there are many cases like Betty Metropolitan Property Realization 1978, Anne's versus the Merton Borough councils. I think this is a case on councils as well, and I think it's about Mrs. Anne's that she suffered some form of losses because she's the occupier and it was given by the building authority. So the London Borough Merton Council is a building authority. So they actually didn't inspect the thing properly and allowed her to move in, stay in the house, and then I think some wall or some floor or something like that actually fall, and then she was injured. I think something to the foundations. I wasn't really sure. I read about the case before. You can search for Anne's versus Merton Borough case. So you see, this sort of situation, there isn't a direct contract between the two parties, but basically the councils are responsible for their actions. So you give this kind of occupation permit, and she moves in, and then she suffers an injury due to your actions or your omissions to act in that sense. So there is a tortious liability. So councils have tortious liabilities for this particular person. And all the cases actually improves and expand and then into different cases that deals with specialists, deals with designers, deals with consultants, So basically, under the law of tort, we are saying that the claimants must suffer some form of, usually will have to have some form of injuries, I would say. And if it's based on pure economic loss, that I suffer money loss, you see, that one is a bit difficult to establish under the law of tort. It's the older concept, but there are some reverting on that concept of economic loss and include pure economic loss as well. But unfortunately, it has been reverted back to the old concept again. And Malaysia is no exception because part of the Commonwealth country. So there was a lot of arguments going on between whether the court will actually accept pure economic loss as a tort claim, you see. So, but from what my understanding is, it has to be some form of injuries by the claimant, and of course, because of that, he cannot work, and because of that, he suffers some income losses and all that, and that is the better reason to bring somebody or sue somebody under the law of tort. Okay, and in the law of tort, basically, so you can read through a lot of different cases that are here in Malaysia, that are here in other part of the world under the Commonwealth, and it actually went on to improve the idea of law of tort. Law of tort actually comes from very, very early under the Donahue and Stevenson's case, which I will explain in a little while. That was the very, very first beginning of the law of tort about loving your neighbors, kind of concept. Well, then, so once we have what are tortious liability, there's 3 areas under tort of law. First is a personal liability, meaning that, like the car case, you drive your car, you hit somebody directly, there is this personal, you have to pay for that kind of damages. And then vicarious liability would mean that I am authorized to work, you see, so I'm a contractor, okay? So I'm authorized to work in this site. I am authorized to do the design as a consultant. So I am responsible, okay? Even though I don't own the project, I am not the owner of the project, but I have what we call vicarious responsibilities. So my person, I'm definitely liable for my action, but the person behind me is also responsible. So these are even though this problem is created by somebody else, but if you are authorize, you are authorizing that person, you have the responsibility. The person who created action also has responsibility. So the vicarious liability and strict liability are pretty much like related to one another. So one person commits, but the person behind who is not doing anything is my contractor did it, it's not me, or my junior designer did it, it's not me, but you're, well, sorry, you own the company, you own the consultancy firm, so you have a strict liability here, and vicarious liability as well to actually directly liable for that tort claim. Okay, so these are the three areas of tortious liability. So from this sort of perspective, you can see that who to pull in, who to pull in, who to sue, So if there's a case, it's not only we sue the contractor, we can even sue the owner of the project, or we can even sue the councils, for example, behind. They're not the one who built it, they're not the one who left the rope on who leave a hole in the floor, and they didn't directly cause it, but they are also responsible. So you see, these are under vicarious liability and also strict liability. Okay, and the concept of tort is always based on negligence. So what is negligence? So we need to understand negligence. So under the Donahue and Stevenson's case, which is the very, very first case ever, it's like Donahue, Stevenson's actually, I don't remember which is which. Okay, so basically the plaintiff is a woman. I think it's Donahue. I think so. Donahue bought, or is it Stevenson's? Mrs. Stevenson's. I think she bought in 1932. So she went to a chemist. Sort of like chemist, a cafe sort of things, and then she bought a bottle of ginger beer, and then she drank it, you see. And then the ginger beer is actually bought by her friend, okay, her friend, who actually shout her, belanja makan lah. So she bought her, and then she drank it, and then after she drank the other half of the bottle, she started to see some decomposed smell under it. So she got really, really sick, So she got really, really sick. So she suffered some form of illness. So she sued under the sales and purchase. She would not be able to sue the chemist, you see. But her friend cannot sue the chemist either, because she didn't suffer any personal injury or losses. So it's almost like a dead case, you see. So herself, she suffered injury, she cannot sue the chemist. Her friend also cannot sue because she didn't suffer any losses. So they didn't actually, the duty of care wasn't established, you see. So then what happened is they end up suing the manufacturer of the ginger beer. Okay, so the House of the Lord lays down that a duty was owed by the defendant to the plaintiff, the manufacturer. So you see, the chemist and also the manufacturer, all of them has a duty of care, especially the manufacturer. So she has the retailer as in the person selling I think it was chemist, I think, but at that time, even cafe was, they lump it under that kind of category lah. And then, so the rule is you are to love your neighbor, because in law you must not injure your neighbor. So who is your neighbor? The answer is somebody who is closely, directly affected by my act. I ought to be reasonable to have them in contemplation. So I'm a manufacturer. My drink is for people to drink. Okay, even I sell it to the chemist. At the end of the day, that somebody is drinking from my action. Drinking from my acts, of making that ginger beer. So this is very strongly established under I think this House of the Lord, and Macmillan was the one deciding over the case. So saying that, even in daily context of social and business and human beings are thrown into a place. So there's a variety of relations with their fellows, human being basically. So this law refers to a standard of a reasonable man. Okay, standard of a reasonable man to take duty of care, okay, to their neighbor, to the people around them who will be using their product or using their goods and using their systems, and they have legal responsibilities. 因为这就是the concept